Supreme Court Justice Neil Gorsuch is being asked to recuse himself from an upcoming Supreme Court case involving a personal friend who just happens to be a billionaire oil baron who wants to gut federal oversight. Now, watchdog group Accountable.us flagged an upcoming case that will have major consequences for health and environmental regulation. Loper Bright Enterprises v. Raimondo as one where Gorsuch has a clear conflict of interest. So now, let me give you some context. Now, the case would remove a 1984 precedent known as the Chevron deference, which established that federal agencies have authority to issue regulatory rules without congressional approval. So now, that's important because it allows these agencies to make these rules without having to go through members of our corrupt, bought Congress. So kind of important if you care about the quality of your food, quality of the air, health, making sure your rivers are not polluted, things like that. Kind of important. Otherwise, of course, it would have to go through Congress, which it receives all sorts of money from private corporations and billionaires. So you can see why it's important for these agencies to have that regulatory power. Of course, they want to get rid of that. Now, Gorsuch has extensive publicly known ties to Philip Anschutz. Now, Anschutz would benefit from this decision to strike down those rules. Anschutz, who has interests in energy, railroads, telecommunications, real estate, and entertainment, has regularly hosted Gorsuch at his Colorado mountain resort called the Eagle's Nest for weekends of dove hunting and speeches on legal philosophy. That philosophy likely being, we should let corporations do everything that they want, whatever they want, whenever they want, however they want, doesn't matter who they crush. Yes. Now, he even recommended Gorsuch to the George W. Bush administration for the 10th Circuit Court of Appeals after he had worked at a law firm that represented Anschutz. So, very important. Looks like they're pretty tight. They're buddies. You could go so far as to say that Gorsuch owes his seat on the Supreme Court partly to Anschutz. After all, had Gorsuch not served on the 10th Circuit, then he wouldn't have been able to prove how much he loves siding with billionaires and corporations. I mean, look at the laundry list of the different decisions that he had made, or dissensions, in cases involving corporations. For example, the dissenting opinion on Trans Am Trucking v. Department of Labor. Now, Gorsuch sided with the company in firing an employee who left his broken down vehicle, truck specifically, during deadly cold temperatures. So the truck was broken down. It was not able to idle to fill the cab with heat. So he had no heat. The temperatures were down to about negative 14 degrees inside the cab. The driver couldn't feel his legs. The frozen trucker case, that's what it's known as, right? Had he stayed with the truck, he either would have gotten, frostbite, permanent frostbite, enough to have limbs removed, have them amputated. He could have even died from exposure. So he leaves the truck, he finds warm, and eventually they go and fix the truck. But he was basically fired for abandoning his load, right? So now he ended up taking the company to court. He actually won his case, and Gorsuch didn't like that. Gorsuch wrote a dissenting opinion, which boiled down to essentially, hey, if the boss tells you that you should die to protect this property, then you should do what you're told. Oh, you have no recourse. You don't have protections. They can take away your livelihood if you don't do what the boss tells you and die. That decision was in the 10th Circuit. That's when he wrote his dissension. Wow. So now, more importantly though, how it applies to this case that is pending before the Supreme Court, Gorsuch had actually written a separate concurrence expressing his doubts about the doctrine of Chevron deference, which permit executive bureaucracies in his words, to swallow large amounts of core judicial and legislative power and concentrate federal power in a way that seems more than a little difficult to square with the Constitution of the framers' design. All that argument is basically boiled down to say that we should allow corporations to do whatever they want, and that includes by members of Congress, so that these regulatory agencies have no power, that you have to rely on that bought Congress in order to actually get any sort of regulations to protect consumers. That's essentially what it is. That's what they're fighting to be able to do, is to make sure that these that regulations, these agencies can't make those regulations. But it seems a little bit more than coincidence here. Look, Anschutz and other billionaires, they can't wait to get rid of Chevron deference, and they know Gorsuch, based on his past opinions, is going to vote to get rid of it. And this is a clear conflict of interest, right? And look, conservatives, when it came to the judicial branch, they played the long game, getting this guy into the 10th Circuit because he knows how pro-corporate this guy is, and then he got on the Heritage Foundation's list of deeply conservative pro-corporate judges and was chosen by Donald Trump. So to be a member of the Supreme Court for life. Part of the plan for corporate rule. Now, President Accountable.us, Carolyn Ciccone, says this: not only would overturning Chevron deference strip power from federal agencies, harming their ability to serve everyday Americans, but now we know billionaire oil barons would score big from a favorable ruling by his friend on the Supreme Court. Yes. She added, it's far past time for these justices to stop putting their billionaire pals over Americans. Recusal from cases where they have glaring conflicts of interest is the very least they can do to restore some semblance of credibility and integrity to our Supreme Court. Now, of course, I look at that and think, well, that's exactly the reason why they wouldn't want to recuse themselves. Look, do you think they care at all about credibility and integrity in the Supreme Court? No. In fact, they've gone out of their way in some of their decisions to say we have no credibility, or in some of their actions. We have no credibility. We have no integrity. We're up for the highest bidder. We're for sale. So yeah, of course, take us out on fancy dinners, shower us with gifts, pay our families, house payments, car. It doesn't matter. We'll take it. We're corrupt. Of course we're going to side with you and not recuse, because there's no reason for them to do so in their own minds. And there's no vehicle to force them to do it. Look, there's not a damn thing that any of us can do if he decides to take this case and rule favorably. Oh, we've got a code of ethics, though. No, you don't. No. If it's not enforceable with real penalties for breaking it, then it means nothing. Absolutely nothing. Again, do you think that they, members of the court, care about their image, the conservative ones? No, of course not. They're there for life. No one can get rid of them. Sorry. The only way is impeachment, which requires Congress, a supermajority vote. Of course. If you think Republicans in Congress would remove one of their own for having conflicts of interest with giant corporations like oil companies, and that was appointed by Trump? No, you're crazy. You're crazy. You actually think that we have a functional democracy here, that we have systems in place to prevent corruption. We don't, unfortunately. And so, speaking of Democrats, by the way, they would probably never attempt impeachment anyway. So don't be surprised if the court takes Anschutz's side and empowers corporations and guts federal regulatory power.